difficulties during the meeting. And we will, ACA staff will be happy to assist you with troubleshooting or getting you on an alternate way to participate, such as calling in. So just shoot us a note if you have any technical difficulties. Now I'll turn to our Vice Chair and Executive Director, Matt Weiner, for any opening remarks.
Yeah, just very briefly, thank you, Matt, and thank you, Connor, and thanks especially to all our members for joining us on a Friday afternoon as we continue our important work on the disclosure of agency legal materials. The only thing I'd like to say before I turn it back over to you is to say how grateful we are that Don Elliott, our distinguished senior fellow, has joined us yet again as a consultant, agreed to serve as a consultant again, this time joined by Professor Galprin. I would like to thank them for the excellent report that they've submitted to the committee, which is, I'm sure that all of you who have read it can tell, was many months in the making. That's all I have, Connor. I'll turn it back over to you. I don't want to take up any more time, especially as we're meeting on a Friday, which is somewhat unusual for us, I think.
First day of the week with sunshine here in DC too. So
that's true. It's a beautiful day out. Yeah.
I will quickly go over the ground rules, which you probably all heard before. But as you know, only ACUS members, so that the government members or designated alternates, we have several of those folks, public members, senior fellows, liaison representatives, special counsels, whether or not you're on the committee or not, have full speaking privileges. Those who are not ACUS members should write in the chat function if you would like to speak. Please keep your microphone on mute and use Zoom's hand raising feature, if you all see that on the bottom, to request a place in the queue to speak. And then I'll call on you. Matt Guth can help me keep the queue, but the Zoom hand raising function is the easiest way to keep the queue. And then reboot yourself when you're done. And please, when you're speaking, use the webcam, turn your webcam on. For the non-ACUS members, the participation requires unanimous consent of the committee members. So, assuming we have time, I'll consider calling on those folks at appropriate points, and we'll presume consent absent an objection. And again, please use the chat feature to request to be called on. With respect to the chat function, this is an important one. Please just use it for asking to be put in the speaking queue. Please do not hold sidebar substantive discussions in the chat function, or we're going to start going up in different directions, which I've seen happen, and we'll lose kind of focus. So just use the chat function for the process stuff. And if we do need to vote, only the members of the rulemaking committee, the Committee on Regulation, which is us today, have a vote. So please don't vote unless you are a committee member. So ACUS members who are not on the committee should not vote. And Matt and I have a list of committee members we can help in case you're unsure. As our Vice Chair, Executive Director noted, Don Elliott is a ACUS Senior Fellow in addition to a consultant, and he will be participating solely in his role as a consultant today, which is something that similar situated folks have done on this committee in the past. So with those preliminary items out of the way, I'm going to turn it over to our consultants to do a presentation on their excellent report, which we thank them a lot for. I'll just briefly note, Don Elliott has extensive ACUS experience. He's probably one of the very few people who's been a law professor and a successful practitioner and a government general counsel at EPA. So he's sort of done all three things. Maybe you've been a part of 4 law firms, Don, is that right? As well as teaching at the Yale Law School for many years and publishing all those years. One of my mentors, who was a classmate of Don, said he's the only one to successfully keep a foot in all those rings. Josh Galprin is a scholar, works in the field of administrative law, among other things, including environmental law, has practice experience and has worked at the Southern Alliance for Clean Energy and brings a lot of good background to this project as well. So with that, I'm going to turn it over to our consultants for a presentation of their research.
Well, Connor, thank you very much. And Matt, thank you for giving Don and I the opportunity to do this. I'm going to keep my remarks brief, just so that there's plenty of time for you all to have a good discussion. Of course, Don and I are happy to answer questions, rather, if you have any for us. But I just want to give you sort of the highlights of our research and our findings here, and then listen to what you all have to say. So to start, just want to make a point that notice of significant regulatory changes is an important topic. It's important because, as a practical matter, agencies are likely to achieve more voluntary compliance if they give regulated parties effective notice of significant regulatory changes. As a legal matter, it's also important because what counts as adequate notice for due process purposes changes as technologies change. And obviously, there's been major technological changes since the advent of the Federal Register in 1936. So it's important for agencies to consider which combinations of tools for giving notice provide, quote, the best practical or the best notice practical under the circumstances. And that's language that the Supreme Court has used when discussing the effectiveness of notice giving. Now, we understand that agency goals, the nature of a regulatory change, and the intended audience for a particular regulatory change, these are all very important factors that are going to vary from agency to agency. And we shaped our research and the proposals that we've sort of put forward. We've shaped all of that with a recognition that there's no one-size-fits-all approach to this. Now, in terms of our methods, we spoke to dozens of people, roughly 60 people, about agency notice practices. We spoke to agency staff, regulated parties, regulatory beneficiaries. We spoke to business groups and NGOs, big and small, unions, micro businesses, community groups, hobbyists, organizations that work for and with people for whom English is not a primary language, state government officials, and other scholars. And from these conversations, we found that larger, more well-resourced groups are more satisfied with current agency notice practices. They're more satisfied, particularly as compared to smaller, less well-resourced groups. Large groups have the resources to connect directly with agency staff and to regularly access and review the Federal Register, for example. In contrast, smaller organizations do not have the same staff resources or contacts with agencies. However, even the larger entities that we spoke with, they identified areas where they think there's room for improvement. Larger entities were particularly concerned about regulatory regimes that emerge from dispersed materials, such as guidance documents that aren't published or aren't necessarily published in the Federal Register. So in addition to some of these concerns and areas of identifying areas of success, our conversations also uncovered a wide array of tools that agencies currently use or should consider using to provide effective notice. And those tools, which I'm not going to go into all the details here, but those tools include fairly obvious things like more use of the Federal Register, and then things like providing digests and user manuals or offering clear instructions on how to access information on agency websites, and ways for agencies to sort of better interact with intermediary organizations. Now, of course, the various tools we encounter, they all have pros and cons, and their usefulness is going to vary from agency to agency. So our report highlights, again, lots of these interesting tools that agencies should consider, but our primary suggestion is a procedural one. We're not necessarily offering any of these tools as best practices in any or all circumstances. Instead, what we think is a best practice, probably across the board, is that agencies should develop notice plans. And notice plans should identify potentially interested parties. They should evaluate the various tools at an agency's disposal. They should consider the costs and benefits of different tools. And they should include strategies and metrics for agencies to regularly evaluate the effectiveness of each tool so that agencies can update their strategies based on real-world experience. We believe that understanding the available tools and using these notice plans as a framework will help agencies provide more effective notice that accounts for the differences between the many agencies that make significant regulatory changes. And with that, I think I'll stop and see if Don has anything to add.
I don't have much to add to what Josh has said, other than it's been a pleasure working with Josh, and he did most of the work, so that's why he's the first author on this. I had the original idea, and I will say that there's a broad range of effectiveness of notice among agencies. So if you're from an agency that's doing a good job, that's great. There's some other agencies where there really are problems, and rather than naming names, we just want to facilitate the process of exchange of information. In addition to notice plans, I think one of the most important recommendations that will be before you is the idea of periodically following up on this topic and convening some fora in which agencies can share experiences with one another. And with that, I'll stop and turn it back to the chair.
Connor, can I just jump in? One thing I neglected, and Don alluded to it. We should acknowledge that Don did suggest this idea and bring it to us, and we were very excited about that because it dovetails nicely with other disclosure-related initiatives that we've been undertaking over the last several years. So I just want to point that out.
No, I think
If
some
I
of that
could,
language.
if I could just make one comment along those lines. One of the things that we did here, and I think under Matt's leadership, ACUS is doing it somewhat more frequently, is we did a smaller preliminary project just to really explore whether or not there really was an issue here. And we concluded there was, and then we came back and proposed to do a fuller study. But I think that's a useful practice based on my experience, is to do a preliminary study to make sure that there is really an issue that needs work.
Don, yeah, and Connor, if I may, just further to Don's point, if I could just sort of put that a little bit in ACUS parlance, we have with, I think, more frequency, as Reeve could elaborate upon if he'd like, we have with greater frequency over the last few years commissioned studies through what we refer to as our Office of the Chairman, without pre-committing to put the project sort of on a recommendation track before a committee. And it gives us an opportunity to review the research and assess whether it lends itself to a recommendation. And so this is an example of that practice that we have resorted to, I think, with greater frequency. Is that correct, Reeve?
Yeah, that's absolutely right. Indeed, there's another project this cycle, Contractors and Rulemaking, where we did exactly the same thing, had a preliminary report, and I think it's worked well as a model.
And our reports sometimes are valuable in their own right, intrinsically, without regard to whether they yield a recommendation. And yet another example is the project that we're doing now, the pretty extensive research study we're doing on nationwide injunctions and how they affect regulatory programs. And that won't likely yield a recommendation, but it will yield a very extensive research report that we think will be valuable in any number of respects. So Connor, thanks for that allowing me to sort of indulge me on that little diversion.
I was just going to say the last paragraph of the preamble, I think, does a nice job of situating this project in some of ACUS's recent work on this theme. So before we proceed, I want to open the floor for any questions to our consultants about the report. Thoughts or questions about the report? Okay, hearing none, I am sure that our consultants would welcome feedback offline. Our task today is to work on the recommendation, but I'm sure they'd be receptive to discussing any feedback you have on the report. So thank you again to Josh and Don. So I will then move to the recommendation, and as we often do, I think we'll work through the recommendation first and then circle back to the preamble second. As Josh noted, what we sort of have here is a sort of a division between process and then sort of more substantive, maybe the wrong word, but strategies for providing that effective notice, and then a circling back at the end to some more process in terms of assessment. So I think it's one way to think about this is to think about sort of process procedure and then some suggestions for getting notice, and then some more process and procedure. So what I'll do, I'll just give a few minutes if folks have, before we dive into the text, if folks have overall reactions, comments on the recommendation, I'll just give a few minutes for any of those sort of thoughts. I'm going to reopen my chat function here so that I can see if anyone has anything. And so I'll open the floor now for any overall comments on the recommendation. Okay, hearing none, then let's go in and let's work on the first. Let's just start with the first 2 points. So developing notice plans, and I will kick off with one thing that occurred to me. Do folks think we should drop a footnote defining significant regulatory changes? I know there's a definition of that in the report. Do you think that's something we should use? Should we carry that definition over? And I'd welcome the consultant's thoughts on that. Please, Don.
I thought we like to discourage footnotes in the recommendations. Maybe I'm wrong about that, but we could define significant regulatory changes by essentially saying immediately after we use the term what we mean by it. And I think that would be good. We in the report take the view that significant regulatory changes are changes that can reasonably be expected to change a change behavior, or that interested parties would be interested in knowing about. That's what we mean by it. And we spent a lot of time considering significant regulatory changes, and we considered other approaches. We considered defining significant regulatory changes in terms of the various devices that the agencies might use. And we decided that didn't really work very well because agencies use different devices in different ways. So we thought a functional definition was better than defining it in terms of what particular legal device the agency used to make the change.
I personally like your definition a lot. I would be curious what Reeve or Matt Weiner or Matt Gluth think about the best way to incorporate the definition, if it's in the preamble or if it's somehow in the recommendation. But
I can weigh in on that. Yeah, Dawn is correct that we do have a preference against footnotes in the actual recommendation portion. I am sort of agnostic as between putting it either here or in the preamble. Though I think if it's going to be a somewhat lengthier text, it might fit better in the preamble. But if we can do it rather succinctly, then I think there's probably some virtue in doing it in the recommendation itself, just so that it, stands alone. So those are my thoughts. I'm fairly ambivalent between the two, but I think it partly depends on sort of how lengthy the definition is going to be.
what do other folks think? Both about the definition itself and if there's any preference about where to put it.
One thing you could do, I don't know how this works stylistically exactly, but I mean, it could be conspicuously marked off in the preamble with some kind of heading or something. I mean, that's a possibility too, if there's a concern that we get lost here.
Would the committee feel comfortable with the committee on style, try different ways to integrate it in? And then everybody will have a chance to react to it next draft.
Works for me.
Any comments on the substance of the definition itself? Other comments on 1 and 2 in the notice plans? Another comment I had, do we want to just throughout use significant regulatory changes? So like at line 58, Matt Gluth, where it says agencies regulatory changes, should we just to keep the scoping consistent, but agencies significant regulatory changes? know what our consultants think of that. Yeah, okay. My sense is we want to make it kind of a global scrub for that, just so I just think at plenary, we could get questions about scoping and definition. I see, thank you for using the hand, Annalise, I see a hand. Apologize if I mispronounced your name.
Yeah, hi, thanks, Connor. Yeah, I'm from Department of Transportation in San Luis. And one change that we'd like, sorry, this is a separate topic from the significant regulatory changes definition. But in reference to recommendation one change that we had discussed at DOT and would like to propose is kind of broadening that language a little bit. So the agencies should consider developing general notice plans as appropriate for their stakeholders and the needs of their constituents. I think that we support the idea of the notice plans and think that they could be useful. But for example, at the Department of Transportation, we have a number of sub-agencies. So perhaps it'd be more appropriate to do notice plans for particular sub-agencies or to have different notice plans, and to have that flexibility, I think would really benefit at least our agency and potentially other agencies as well.
Thank you. Reactions? More consultants or others? Don?
We considered that, and I think all of the other things we say that agencies should just consider. We think this recommendation is general enough that really we came out in actually recommending that agencies at least focus on the problem by having a general notice plan, but we don't have much content to it. Having said that, I don't think it really makes that much difference, but it was an intentional decision to actually recommend the notice plans, and with regard to everything else, say there are things that agencies should consider.
Yeah, thanks. That's helpful. I think from, like, as I was saying, from DOT's perspective, a general notice plan that would cover all of the Department of Transportation may necessarily need to be so broad that it may not be particularly helpful. So to have something more tailored for our agency and to be able to consider the ways that we might implement notice plans across the department might be, specific. It might be a specific need of DOT.
Don?
Yeah, I was a little bothered by the word general, and I don't think it was our suggestion or thought that there had to be a single notice plan for an agency like DOT. So an alternative might be agencies should develop notice plans as appropriate for stakeholders and the needs of their constituents. Because I think, it is certainly the case that at agencies that I know, like EPA, you don't necessarily have to have one. I mean, you might have separate ones for the separate programs, but really our thought is just that people ought to think about it and plan it. What we found in our research is that sometimes agencies have the work group that essentially put a rule together, take charge of notice. And what we were trying to do is to make thinking about notice somebody's actual responsibility within the agency. So, in agencies, if nobody is particularly responsible for it, then it tends to get less focus, at least in my experience. So that was the theory behind it. But I don't think that we care. I don't feel strongly about it, about consider or not consider. There are some people in the plenary who object to too much use of the word consider, but that could be fine.
Yeah, I think one other thing that I'll add is that, within the department, this is definitely the Department of Transportation, this is something that we do. We don't necessarily have like something that's called a notice plan, as contemplated here, but we have, an Office of Public Affairs, and we have people whose job it is to ensure notice. So it may not be something that each agency needs to change theirs and make something and put a title on it called general notice plan. So just one more thing I'd add.
I didn't think about subunits. That's a good point. When I read general, I was thinking, there's nothing's omitted. But I could see how that would read differently with a different agency structure. So I don't know. I think Josh, go.
Sure. Briefly, I was just, of course, I agree with everything that's been said, but I was going to just add that I think when we put the word general in there, our thought was more general, as in not rule by rule or regulatory change by regulatory change, not specific to the change, but it wasn't meant to indicate that it should be for an entire department. I think whether it's for a subunit or not is not the core idea here. The core idea is that it's overarching different regulatory programs as opposed to for an individual regulatory change.
Additional comments on this point? My inclination would be that we let the Committee on Style think about a better way to convey the general point, taking out the word general, but trying to convey that it's not rule by rule. And then we take a vote on whether or not to include the consider and the other qualifiers next meeting after we see how this all looks, since it's the first part. Matt, if you could just mark that plan, I think we can revisit this quickly at the next meeting. Take a vote. Other questions on, or other comments on 1 and 2? Okay, hearing none, let's go to the next page and just open it up. This is sort of expanding on the notice plans and just do 3, 4, and 5, and 6. So that would be line on Matt's screen, line 64 through 78. Any comments on this part? Okay, Jim Tozy, thank you.
I have a question, nothing with the writing, but do agencies have, I think it's number 4 said, in developing their notice plan, agencies should obtain feedback from interested persons. Is that, do agencies have by rule? Do they know? How does that work?
Don?
I think that we didn't want to be too specific, Jim, as to specifics, but in the report, we talk about the possibility that agencies would periodically take comments on their notice plans, but also do follow-up studies in the way that invite feedback. Some agencies, including EPA, when you use their website, for example, they send you an email essentially, or a notice asking you if you would like to comment and what you think is most effective, and if you have any suggestions. So there's a pretty broad range of approaches that are talked about in the report for how to obtain feedback. But I guess our feeling was, and you could certainly work some of those in if you wanted. You could say, that they should obtain feedback, and you could say, methods for obtaining feedback could include the following. But one of the things that we found is that agencies tend to be a lot more satisfied with their techniques for giving notice than most of their constituencies are. And that's in part because at most agencies, and not all of them, but at most agencies, it's simply a matter of complying with the legal requirements. And we found that lots and lots of the users had good suggestions for improvement. And what we're trying to do is to broaden the discussion so that the topic of what works best for providing notice of significant regulatory changes would incorporate the thoughts of the user communities as well as the agency personnel. Josh, I wonder if you wanted to add to that, because you talked to a lot of people along those lines.
No, I don't think I have anything to add to that. Thanks, Don.
Well, I think your idea of, I guess I missed that you were going out for a comment on the notice plans, and that would go on, and I guess I missed that. I think some agencies, like, I think EPA has a very good track record on that. But I think there's some other agencies who'd rather have people go away. So, and I'm just wondering, so I think, yeah, is this idea of those notice plans going out for comment, is that in a recommendation here any place?
I think just indirectly through this point. So we could
I think it's very
Consider-
interesting.
add something like strategies may include and then build
Okay, yeah, that'd do it.
something out.
I got it. Okay.
We could draft something for folks to look at next time. Don Elliott.
When we suggested recommendations, we specifically suggested that agencies might consider seeking comments, and that did not make it into the draft. We toyed with the idea of whether notice plans should be go through notice and comment rulemaking, and we decided that that was too prescriptive. But the idea is to try to incorporate feedback on an ongoing basis from interested parties, because as we talked to people, there were a number of surprises as to what people found effective and what they didn't find effective. And we're trying to take this a little bit more in the direction of empiricism and using some of the techniques that that private parties use. And it's very frequent that when you do something online commercially, you get asked to fill out a survey and how could we improve and so on. So we're trying to see if we can encourage some of that culture within the agencies.
Fine.
Peter.
Thanks, and I apologize for joining late. When you said the word survey, one of the concerns I just had from the federal perspective is avoiding raising FACA implications if we're trying to get consensus, or Paperwork Reduction Act if we're sending out surveys. So that was, I don't know if we need to go into that here, but I was thinking along the same lines of if we did some sort of outreach. It's interesting at DOL along the equity outlines, we're doing some engagement and trying to find out from groups, all right, if you don't have access to computers or the Federal Register notice. So in some ways, it's not doing surveys, it's not consensus building, but when we have that opportunity, it's sort of finding out what's the best way to educate folks. But yeah, I would just avoid the surveys or, again, things we're trying to do consensus building. Thanks.
As we draft something, we'll bear that in mind. Steph Tatham.
I can understand that concern, but I will say that I do think under the Paperwork Reduction Act that this type of activity could be considered customer service delivery related. And so it might be able to qualify for like a fast track generic clearance that could be expedited for review here in OMB. So that's certainly an option for agencies. If agencies obtain feedback through general solicitations in the Federal Register, of course, that's not covered by the PRA. But in terms of individualized outreach, it's also not covered by the PRA as long as the questions aren't identical and it's tailored to the recipient. So I think we have some recommendations that include language to this effect. I'll take a look for it and try and send it over if you want to include that in the preamble. Maybe it's too in the weeds, but I guess what I'm just trying to say here is that I don't want agencies to worry about the PRA too much, because I think that there are ways to do this consistent with the PRA.
Thank you. Good points.
Yeah, and just to add to that, this might be a good topic to address in a little more detail in the preamble and give some specific examples. We thought that some agencies might actually want to set up advisory committees about this, and other agencies might not. And so we were trying not to be prescriptive, but just to say that they should consider ways of obtaining feedback, but we do think that those kinds of feedbacks might differ from agency to agency. And in some places, some of the most effective techniques really did entail something very much like an advisory committee where particular constituencies were represented, and you can't talk to everybody, but you can talk to representatives who are typical of particular groups. And if you have underserved groups, it might we found a lot of surprises in terms of what people said.
Thank you, Don. Are folks comfortable with us trying to list some examples that Don said methods for obtaining feedback could include, and then seeing how the committee reacts to that next meeting? Additional feedback on recommendations 3, 4, 5, and 6. Okay, hearing none, then we're going to move to the list of strategies. So what we have here is, as you've seen, are some factors here for agencies to sort of assess what notice strategies they may wish to undertake. And then we have sort of a long list of possible strategies. One, just on rereading this last night, one question I had is, and this is something I've heard discussed with Don and Josh and Matt, is that agencies have different situations that might make some of these strategies more or less effective, and so they have different constituencies. As Don was saying, some have constituencies that are probably better resourced. Some have constituencies that are less resourced. Agencies also use different regulatory strategies and methods. Some agencies rely more on adjudication to make policy. And so I wonder if either here in the preamble, we want to just give a nod that sort of the correct strategy will depend on the agency's circumstances, and maybe list some of those circumstances. So I'll just open that question up to the committee, including our consultants. Don.
Well, we went back and forth on that in the report. We think you could say that over and over and over again. So we tried to say it once and then have it apply to everything. But I think this might be a good place to say it because it certainly is true. And as Josh said, we don't think one size fits all works here because of some of these differences. I think it would be useful to recite some of the factors that can cause agencies to be different. I actually think that the preamble is a better place to do that than in the recommendation. But working in some reference to say that no single strategy is going to work for every agency. I think we strongly support that idea.
Other reactions on if folks want to say something like this, and if so, where? Okay, are folks comfortable with the Committee on Style playing around with this and adding it either to the preamble or possibly here in the recommendation and then letting the committee look at it next time? My guess is this is a comment we'll get from, at this point, will be raised by other agencies down the road. So I think it's better to try to address it somewhere up front, but we can play around with where. Okay, what I'm going to do then is, and Matt Kluth, if you can just shrink down the margins, if you double click in the sort of space between the pages, we can see more of it. Let's open up whatever we can fit on one page for comments. You can take it off print view. I think it's under view. maybe make it bigger, and then we can see a lot more. You can just scroll down. We can probably see a lot of the strategies. Okay. Well, let's just open it up for 7 and 8 then. Comments on 7 and 8. 7 is sort of a overarching recommendation to guide agencies, and then 8 gets into the Federal Register. So I'll open up for comments on 7 and 8. Alice Kottmeyer.
Yeah, maybe I need to go back to, Professor Sunstein's text, but how do you do a significant regulatory change without publishing it in the Federal Register?
For example, a big adjudicatory decision.
Okay, because we don't do those.
Yeah.
Okay. Yeah, I can't imagine the Department of State ever doing that. We don't do
Potentially
adjudication.
a guidance document. So yeah, yeah.
Okay.
And this, I think your point cuts to the differences between agencies, and why we're kind of giving options for agencies to consider, but not best practices and not being prescriptive, which I think is critical. Don.
Yeah, and I'm sorry.
No, go ahead, Alice. I didn't mean to cut you off. Go
No,
ahead.
I was just going to make one other point that, I was a little bit concerned about this whole set of recommendations and the interplay with the idea that Federal Register legally provides notice. And I have to think about that a little bit more, but we're of the view that the Federal Register already provides the legal notice to everyone, because that's the whole point of the Federal Register Act, I think. But anyway, that's all. Go
Okay,
ahead.
welcome. If you have thoughts between the meetings, the language, feel free to shoot it to us. Don Elliott.
Yeah, just 2 things. One, there's some excellent examples in the report that Josh wrote of things that would be considered significant regulatory changes under our very broad definition, because they could be expected to change people's behavior, even though they are not formal changes in the language of the rules. So I would refer you to that. With regard to the point about publication in the Federal Register being considered adequate legal notice, that of course is the case. However, as is noted in a footnote in the preamble that we will eventually get to, there are some cases, including a Supreme Court case, that suggest that notice by publication may not be sufficient under certain circumstances. So I would propose that we just delay that until we get to the preamble. But there are some potential risks, because there are some Supreme Court cases, even in situations where you had a statute establishing a public notice by publication as being sufficient, and the Supreme Court holding, well, that's not under particular circumstances. So I think that's an important issue for agencies to be aware of. And Connor and I have gone back and forth on this a little bit, and I think we agree that ACUS as such shouldn't try to predict the future direction of the case law. But we in the consultants report describe the cases, and there is at least one case in the Federal Circuit that applies that test. So those are cited in a footnote in the preamble, and I think where Connor and I agreed is that we just should disclose those cases to the agencies, and the agencies can consider to what extent they do or do not constitute legal risks. But in the circumstance of the Supreme Court case, the parties had been exchanging information by mail, and there was a history that they had people's addresses. That is also the standard under Rule 23 of the Federal Rules of Civil Procedure, which are not directly applicable, but for class actions, if it's practical to provide notice in some other way that's more likely to get to people, publication doesn't necessarily satisfy it. So I think what we were worrying about is a situation in which there was sort of a practice of notifying people by email, but then it just was published in the Federal Register, and there were a whole variety of factual circumstances. So we didn't try to address them, but just and plus the other thing is there are lots of significant regulatory changes, as we're broadly defining the term, that are not published in the Federal Register. And we think one of our most important recommendations is that if you're not going to publish the full text in the Federal Register, if it is significant, maybe you should at least publish in the Federal Register a notice of availability with a link to where it's available on the websites.
Yeah, and the corresponding footnote that Don's referring to is footnote 1. So we can discuss that when we get to the preamble, but that's in footnote 1. Matt, go real quick on line 80. I see another example where we have specific regulatory changes. We probably want to track. Well, we can do a scrub, but make that significant just so we're consistent throughout. Stephanie Tatham.
Well, this follows well on Don's last point, but I was just going to suggest a minor verbiage tweak in line 90 to number 8 to say that agencies should consider publishing notice of significant regulatory changes, because I do think that there are potential cost savings in terms of having like a combined notice of all of the significant regulatory changes that would make it, less costly to publish and still serve the same constructive effect by providing a link to the document that has the significant regulatory changes. So hopefully that's well taken, given Don's statement that that's something that agencies might want to do anyway.
I just wonder if is that idea covered in number 9, or notices of availability something different?
That's a good question. I don't know, maybe Don could speak to what the difference is between these two.
Well, I agree with inserting notice of in 8. I do think that they were intended to be different. And 8 was intended to say you should consider publishing the whole thing. But even if you're not publishing the whole thing, you should consider publishing brief notices of availability. So they were intended to be a little bit different, but I don't have a problem with inserting notice of.
And I don't have any concern with keeping them separate if they really are separate concepts. I guess I feel like if we really want agencies to consider this, like the cost of providing the notice is pretty low and the benefits seem potentially high. So just trying to understand, and maybe preamble language could explain when they should do the full publication versus just the notice of the publication.
Yeah, I think that we don't want to be too directive, but there are two separate ideas here. And sometimes it makes sense for agencies to publish the full thing in the Federal Register, and in other circumstances, because of cost and other factors, brief notices are better. And maybe the Committee on Style can consider figuring out how to say that. But we think sometimes, even if it's not required by law, agencies should at least consider whether or not they deem the benefits of providing, and I think maybe the word widespread notice in a single place doesn't quite get it. It's not just widespread, but it's also providing the detailed notice that comes from the Federal Register. I suppose the complaint that we heard most frequently, and I refer to Josh, who conducted most of the interviews, but I think the complaint that we heard most frequently is not everything's published in the Federal Register. And if there is a very significant guidance document that doesn't have to be published in the Federal Register, maybe agencies should consider, just like they sometimes take public comment on things, even though it's not required by the APA. So that was the idea we were trying to drive at here.
And I'll just add something very, very brief to that, because Don's right. That the concern that our interviewees raised was that not enough is in the Federal Register. But I think there was a real willingness to distinguish between a significant a user manual, for instance, which is something we discuss in the report and it's raised in the draft recommendations. A user manual could be hundreds of pages. And I don't think anybody was suggesting that that ought to go into the Federal Register. That would be the opportunity to use a notice of availability and say, take notice, there's a 500-page document up on our website now, and summarize it in the notice of availability. Whereas a briefer guidance document, a 5-10-page guidance document might be appropriate to publish the entire document in the Federal Register. So that, I think, was sort of the distinction that our interview subjects were mostly focused on.
Maybe we can run this by a few Federal Register gurus and just see the best way to make sure both points are clearly and distinctly incorporated in this. Annalise?
Thanks. Yeah, I just had a couple of questions regarding 7D. Just seeking clarification regarding what is meant by paperwork hurdles. Paperwork to me connotes like a submission or a form of some kind. And is that something that agencies are requiring to obtain their documentation, or is something else meant by paperwork there? And then also, can you scroll down a little bit? Also wondering what types of combinations of agencies, like what types of changes are made through combinations of agency materials, like what scenarios this was envisioning.
I'll let our consultants speak to that.
I can take that, Don, if you'd like me to. So for the paperwork hurdles, we were not, I don't think, referring to filling out forms and things of that nature. It was more about assembling paper from different sources, and perhaps not literally paper. But I think answering the second question will clarify the first. So in terms of combination of agency material, here we're thinking about an agency regulatory regime that may emerge from adjudicatory decisions. And there may be guidance documents or enforcement letters that fill in some of the details there. There may be a rule published in the Federal Register, codified in the CFR, that is a basis, and then letters and guidance that help clarify different aspects of it. So that was the kind of regime where more than some of our interview subjects were concerned that it was too hard to gather all this information on their own. Perhaps too hard isn't the right word, but there was a challenge to gather all this information on their own, and that there might be some ways to address that.
Any responses? Do we want to clarify the link, take out paperwork? Because I agree, paperwork makes one think of like doing forms and like PRA stuff. So I kind of agree with that. Do we have, Annalise, do you have suggested language or?
I didn't have suggested language, but I think that administrative to me, just administrative without the reference to paperwork seems to achieve what it sounds like the consultants were trying to. So I think just deleting paperwork would make that easier for me to understand. And regarding the second half of the statement, I think maybe my confusion just stemmed from the part that said not from a single pronouncement. I guess maybe, and this is perhaps particular to, again, the way the department does things, because oftentimes they'll have supplementary documents. So the change might be a single pronouncement and there are a combination of materials that accompany it. So I'm not sure that, so I think that not from a single pronouncement may not be needed there, but again, that might be unique to DOT.
Okay, well, I think we could consider, I don't know if our consultants think that's necessary, but I think that could come out as well. Steph, did you have a point on this, or did you?
Sorry, my hand is straggling. I'll lower it.
Oh, sorry. Don Elliott.
I agree on taking out paperwork, and I also think hurdles is not exactly what we mean. I think we've talked about, in explaining it, we've used the word burden. And, what we heard from people is that if you have a regime and the example that probably the leading example was the pesticide labeling, where at EPA there are multiple ways that the requirements for labeling a pesticide have been addressed, and EPA has a manual that pulls it all together. And that also is very similar to a recommendation that that Matt and a co-author, Matt Weiner and a co-author recommended, of putting together things that are dispersed in digests and so on. So the idea is to try to reduce the administrative burden on regulated parties to assemble all the changes for themselves. And this is really just an economies of scale point that, you know, rather than having, you know, hundreds of people have to try to put it all together into a coherent framework, the suggestion is that maybe the agency can do that, at least in the first instance. And again, this is discussed at some length in the report. And I think maybe the Committee on Style can work on the language. But the idea is that if there are lots and lots of different documents and you have to put them all together in order to see what the agency's policy is. And we gave several examples, and not just EPA, but also I think the Patent Office does this. Sometimes you have, in order to understand what the requirement is, you have to take into account, you know, multiple documents. And the idea was, rather than leaving that to any individual user or multiple individual users, that maybe the agencies could consider if it would be more efficient for them to assemble it. There are pluses and minuses to that, which we try to acknowledge in the report. But that's what's going on here.
Consider language along the lines of combination of agency materials that require synthesis or something along those lines. Yes, Annalise.
Yeah, one point that I'll make is I don't think that that's necessarily something that my agency would include in our, you know, it's not something that we think of as part of notice or something that we would necessarily think appropriate to include on a notice plan, because that's really more of a question of information management and maintaining pre-existing regulatory changes. So, you know, we have guidance portals, we have ways that we manage our existing guidance, and those are not necessarily well, it's coordinated. When a new guidance document is published, the notice for that is kind of handled separately from the way that we will maintain it going forward to keep a digest or, you know, a portal that maintains all of our guidance documents, regulatory changes, administrative documents, whatever is appropriate to the stakeholders within that operating administration. Those are kind of the information management of pre-existing regulatory changes is slightly different from the way that we notice new regulatory changes.
Additional comments? Okay, hearing none, let's scroll down then and look at 10 through 13. So these are more strategies. So we've got website organization, website optimization, legal summaries, press releases. Comments on how these strategies are teed up. Yes, I see Erica.
Yeah, so I have a question or a comment or something on 12, which is about summaries of legal materials and manuals and so forth, which I agree are really useful. I had a sense, though, that this is really solving a different problem, because it seems to me that there's the problem of, well, it seems to me that there's a difference between knowing about a change and knowing either the universe of things that are relevant to an issue or even sort of having help synthesizing those materials. and I guess what I would say, and just, I'm sorry, I'll be a little bit more articulate. I think manuals solve a different problem. They solve the problem of not knowing the universe of agency documents that may bear on an issue, which I think is especially important if this is what you call a docket agency, or if there are other important non-binding documents that fall within scope. And the other problem that these kinds of things solve is the inability of some, perhaps the smaller companies, as you say, their inability to kind of synthesize all of this and figure out what sort of put together it all means. I don't think they are themselves really attuned to or focused at change. And the topic of the recommendation, as I understand it, is change. The only way that a manual, it seems to me, would be relevant is there is a manual and changes are promptly added to it, promptly integrated into it. And so I don't know what, I think maybe the recommendation of the summaries is a great recommendation, but it might actually be a separate topic for ACUS. And this might be, if you have summaries, promptly update or synthesis, promptly update when there are changes. I mean, that was the first half of my comment. The second half of my comment is in the report itself, there was some discussion of the issue that led to this recommendation. And I noticed sort of the countervailing considerations and the concerns, especially in the last sentence, potential oversimplification with manuals, that relates to the second goal that manuals achieve, which is the synthesis, not the identifying the universe part. And I think the identifying the universe part is a separate thing, actually. I mean, I can imagine a recommendation or an agency that did the following, topic by topic, kind of had links to or citations to all of the things on that topic, not doing the additional analysis that, for example, you see in the patent office manual, but just here's everything, including the the docket documents and the other things that wouldn't appear in the Federal Register that are relevant to this problem, and then supplementing that. So there's a lot of different things going on in here, and I guess I'd be interested in hearing, Don and everyone else's sort of views on my comment and on this recommendation.
Don.
Well, I do agree with Erica that manuals serve multiple purposes. And I just would, I guess it's been taken out, but this was one where we very carefully said this is just something agencies could consider. In some instances, I think you can't really understand a change unless you understand the context for the change, and that's really what we had in mind. That sometimes a guidance document just existing in isolation isn't really clear about what is being changed and what isn't. So again, it's a very weak recommendation because it simply, as it was originally written, it simply said this is one of the things that agencies might want to consider. But I would also agree with Erica that such manuals are not for every agency, not for every situation, and that they serve multiple functions. And I also think that there is a substantial question as to whether or not this is always an appropriate role for government as opposed to private advisors. So we tried to be very gentle about this, and I do think there are instances in which even taking her points about the other ways that manuals, the other functions that manuals serve, I do think there are some instances in which you can't completely or adequately understand an individual regulatory change without the context of how it fits into the pattern of regulation as a whole. And that's the role that I think these summaries would fulfill.
Might I just respond or ask a question? Do you agree though that the key part of this ought to be, since this is about notice of changes, that really the key is not you should do a manual or think about doing a manual, but rather you should, if you have these new things, need to be promptly put in place. Does that make sense, or am I missing something?
Well, I actually think both. I think the notion if you do have a manual or summary, it should be promptly updated. I think that should be a separate sentence. But I also think that part of the process of notifying people of significant regulatory changes may be to provide a synthesis or summary so that people can see how the change fits into the to the texture as a whole. So I think we just have a relatively narrow disagreement on that. I don't think it's out of bounds in a report about notice of significant regulatory changes to suggest that one of the things that agencies might consider is whether a way to improve the way that people get notice of significant regulatory changes is to have a summary or digest. But I would agree with you that manuals or digests perform other functions as well.
Great. Okay. Well, as long as we get at least the sentence in about the prompt updates, I'll be content.
Yeah, and I think that is a very important point, and I think it should be in there. But I don't think we should drop the rest. I think we should add to it the importance of updating summaries.
Erica, if you have additional suggested language, please send it to us and we'll try to work it in.
I'll do that.
It might be easier to just kind of edit this a little bit offline to make sure we're making all the points, also keeping them kind of distinct. Other comments? Did you have more, Erica?
No, I don't.
Oh,
No.
okay.
I'll take my hand down, sorry.
All right, then let's move to the next page and go through, I think we can put up on the screen recommendations 14. You can look at 14 through 19 when you're ready, Matt Cliff. And those cover listservs, social media, blogs, and public meetings, and remote participation. I know some of this reflects what we heard in the pre-form, some feedback we heard in that pre-form. So I'll just open up for discussion on the strategies that are in recommendations 14 through 19. Okay, hearing none, let's go down to number 20 and see, let's finish 20 and 21. So this is the remainder of the strategies for giving notice. This is about training and equipping frontline employees and working with intermediary organizations, which I think is important. It's 142 to 150. Okay, hearing none, let's go down to the assessment and oversight. And I don't know if Don or Josh, you want to say a word about this. I think you briefly touched on it. So I'll just open the floor to you if you want to say any introductory remarks about, especially about recommendation 22.
Well, I don't have much to add on this point other than that we thought it could be helpful not just to create these notice plans, which we think is perhaps the most important recommendation, but to have somebody charged with really being responsible for the process. Because if there isn't an individual or an office in charge, it's very possible that these things will just fall to the wayside. And that's essentially the idea behind designating an officer or office to coordinate, etc. But we also recognize that that's another title for another person. There are some downsides to this too, which is why we thought that this is more of a consideration than something that we wanted to put forward as strongly as the notice plans themselves.
Reactions, especially, well, on either 22 or 23 on the notice officers or offices, or on coordination. Peter.
Yeah, just to say from my perspective, I don't think we'd have much issue with this. I don't think it may be not sort of creating a new position or office, but saying to the appropriate person, this is now going to be part of your duties. So from a ham and egg or Fed side, I just don't see this as a huge issue.
Other reactions? Okay, hearing none, I propose we just take a 5-minute break and then we'll start working through the preamble. So think about comments you may have on the preamble, and what time is it? Let's come back at, let's just say, well, let's just keep it clean, 3:25. So I'll see you at 3:25. Thank you. We'll see you then. Look at that first page of the preamble, Matt, if you can scroll down, yep, right there, and just get the footnotes in, and we'll just welcome comments on this, that's on the screen now, lines 1 through 12 and accompanying footnotes. And this is sort of some of the discussion that Don Elliott had referenced earlier. And so, yeah, I welcome your thoughts and comments. Okay, hearing none, let's go on to the next page that we can view on the screen. This sort of, you want to zoom out slightly, Matt. This gets into some of the background and some of the framing and some of the legal requirements. So welcome your comments on anything in this page. Okay, hearing none, then let's go to the next page, which I think will be lines 40 through 49. So this, the last full paragraph at 45 through 49 is what our Vice Chair Matt Weiner was talking about with respect to how this sort of fits into AGUS's recent work. And so, Don, the other place where I thought the point about different agency circumstances could fit in would be, and I don't know what you think or what others think, but it sort of between lines 43 and 44, or maybe after the sentence ending on 44, that point at the end of this paragraph is where this point could be made potentially, as opposed to the recommendation. But I don't know what folks think. Don't know yet.
I think it's a sufficiently important point that it should be said early and often. I would recommend saying it once in the preamble and saying it again in different words in the in a recommendation, because I actually think that when we get to the plenary, it's going to be something that people who haven't really followed it in that much detail, that will immediately occur to people. So if that would be my preference, is yes, to say it here, but then back at the place where it comes up in the recommendation, maybe say, bearing in mind that not every approach is going to work for every agency, so that, but I think going into it in more detail in the preamble, and maybe even talking about what some of the factors are, because there, we all know a few agencies well, but when you start looking at the range of practice, it's really extraordinary how different they are and how different their constituencies are. Some agencies have constituencies where pretty much everybody is represented by intermediaries or specialists, and other agencies deal with people that are really not represented and may not have access to the internet even. So it's really, really important, and I don't see a problem with discussing it in a little bit more detail in the preamble, and then at least referring to it in the recommendation when we start talking about different techniques.
I like that path, that we could use your and Josh's help in crafting the language. Other reactions to that general plan? Other reactions to the concluding two paragraphs of the preamble?
No.
Okay. Any other comments on what we have? So the preamble recommendation that have come to people. Part of the reason I want to take a break was so people could sort of just regroup. So any comments about where we are, where we should be going? Please, if you have language, I think if I encourage a few folks to send us language, please send us language. If you have ideas, please send it to Matt Kluth, me, and our consultants. We'll have a new draft with track changes well in advance of our next meeting, which is April 22nd at 2 p.m. So that's 2 weeks. So we have plenty of time to incorporate what we've discussed today, get it to folks for review and comment. So if it's, say, in the next week, like by next Thursday, ideally, if you could send us language, that would be really helpful. If you have it. With that, I will turn it back to Matt Weiner and Reeve, Matt Kluth, in case you all have comments or thoughts about where we're going from here.
I do not. I just assume everybody go enjoy the rest of their Friday rather than listening to me.
Same here.
Right. Well, on that note, thank you very much for your thoughts and participation. We'll be back in touch. Send us what you have, and enjoy the rest of your Friday.
Thanks, Connor. Thanks, Don. Thanks, Joe.